Well, hello everyone, and welcome back to Uncivil Law. For today's story, we turn our attention to a federal court of appeals who would like to slap the district court around. The district court has not been doing their job, and the court of appeals isn't content merely to reverse and send things back. No, they'd like to instead beat up on the lower court for a while for not doing their job correctly, and that's always fun. That's always fun watching the lower court get its ass handed to us. So we turn our attention to this case of the Court of Appeals for the Fourth Circuit in United States of America versus Kwame Smith, also known as Animal. That's nice. The defendant goes by the name Animal. United States of America versus Animal. That's entertaining. Appeal from the United States District Court for the Eastern District of North Carolina at Greenville, North Carolina, Terrence W. Boyle, District Judge. All right, let's see how this worked out at the Court of Appeals level. I'm going to try to call him Animal because that sounds funny. Animal pled guilty to robbery and using/brandishing a firearm and in relation to a crime of violence. In his written plea agreement, he waived his right to appeal his sentence. The district court subsequently sentenced Animal to 144 months of prison, otherwise known as 12 years, for the robbery and brandishing a firearm. Okay. On appeal, Animal argues that his appeal waiver is invalid because the district court failed to properly conduct the plea hearing and because the appeal waiver was not knowing and voluntary. Therefore, Animal urges us to vacate his sentence as procedurally unreasonable because the court failed to acknowledge his non-frivolous mitigation arguments or provide an explanation for the sentence. We hold Animal's appeal waiver was not knowing and intelligently made, and enforcing the appeal waiver would result in a miscarriage of justice. Therefore, we vacate the sentence as procedurally unreasonable and remand for reassignment to a different district judge. Ouch. Ouch. I mean, that hurts. Not only am I sending it back, but I'm going to send it back to a different judge. Woof. You got to feel that one, man. That is not a good day. All right, let's learn a little bit more about Animal and his frivolities. In May 2021, Animal, along with the co-defendant, robbed a gas station in New Bern, North Carolina. The robbery was captured on surveillance video, which was obtained by law enforcement. Animal entered the store armed with a revolver. He approached the counter, pointed the revolver at the cashier, and demanded money. Animal then ran behind the counter, struck the cashier on the head with the revolver, and took cartons of cigarettes as well as money from the register. The surveillance video showed Animal and his co-defendant leaving in a Honda CR-V. A witness took a photo of the vehicle and provided it to the investigators. The photos show that the vehicle had a pink trim vinyl sticker on the body, a white diamond-shaped sticker on the driver's side rear windshield, and a baby on board sticker. That's hilarious. A witness to the robbery chased Animal and his co-defendant, flagged down a police officer during the chase, and identified the Honda CR-V as the getaway vehicle. The following day, law enforcement located the getaway vehicle, which was registered to the father of Animal's co-defendant outside of a residence. In plain view, inside the vehicles, officers saw unopened packages of cigarettes matching the type stolen from the gas station. These guys aren't really trying very hard. In plain view, I can see the cigarettes that you stole from the gas station. Animal needs to work on his procedures better, man. Oh, man. While officers were at the home, Animal and his co-defendant exited the residence and were arrested. During a frisk of Animal, officers recovered more cigarettes in his backpack. The loaded revolver, which was used during the robbery, was recovered during a consensual search of the home's garage. Animal was indicted for robbery in violation of law, using and brandishing a firearm in violation of law, and possession of a firearm by a convicted felon in violation of law. Animal agreed to plead guilty to counts 1 and 2. As part of the plea agreement, Animal agreed to the following: To waive knowingly and expressly the right to appeal the conviction and whatever sentence is imposed on any ground, including any appeal pursuant to law, and further to waive any right to contest the conviction or sentence in any post-conviction proceeding, including any proceeding under different law, accepting an appeal on or motion based upon grounds of ineffective assistance of counsel, or to prosecutorial misconduct not known to the defendant at the time of the guilty plea. The foregoing appeal waiver does not constitute or trigger a waiver by the United States of any of its rights to appeal via law. So, as is very typical when you are giving a guilty plea, you typically waive your rights to appeal. And how much of you're giving up, of course, can depend on the plea agreement, but this is a pretty typical one. Basically, you are agreeing that you won't appeal in the conviction, you won't appeal the sentence. The only thing you can appeal is ineffective assistance of counsel or prosecutorial misconduct. And also, the government can also appeal if they believe the sentence is too short. So you can't appeal if you think it's too long, but the government can appeal if they think it's too short. So that was the deal. For its part, the government agreed to dismiss count 3 of the indictment and to recommend a sentencing adjustment for the acceptance of responsibility. On February 16th of 2022, the district court conducted a plea hearing, which lasted 16 minutes. The court confirmed with defense counsel and the government they had no concerns about Animal's competency to enter the guilty plea and found that Animal was competent to proceed. The district court questioned whether Animal was satisfied with his attorney, and Animal indicated he was. The court questioned whether Animal understood that by pleading guilty, he would waive or give up various rights, including the right to a jury trial at which he would have the presumption of innocence, the right to confront and cross-examine witnesses, the right to counsel, the right to call witnesses, the right to testify, and protection against self-incrimination. Animal responded, "Yes, sir." The district court determined that Animal had received a copy of the indictment and informed Animal that the elements of the crime to which he was pleading guilty were set out in the plea agreement in paragraph 3 on pages 4, 5, and 6. But the court did not review the elements of the crime with Animal. With respect to count 1, the court stated that interference with commerce by robbery and aiding and abetting that is a 20-year crime, fine, supervised release, and special assessment. With respect to count 2, the court stated that brandishing a firearm during a crime of violence and aiding and abetting that is 7 years in addition to any other punishment. With respect to count 3, the court stated punishment for that is up to 10 years in prison, fine, and supervised release. In response to the court's questions regarding whether the court had accurately described the crimes to which Animal was pleading guilty and whether he understood the charges and punishment he faced, Animal again stated, "Yes, sir." Regarding the waiver, which is what brings us to the issue today, the district court explained you're entering into a plea agreement in which you're pleading guilty to counts 1 and 2 of the indictment, and you waive your right to appeal and waive your right to contest the conviction in any post-conviction proceeding. After summarizing the remainder of the plea agreement, the court asked, "Is this what you agreed to?" Animal stated, "Yes, sir." The government provided the factual basis for the crimes to which Animal was pleading guilty. The government recited Animal's conduct during the robbery and noted how witnesses had assisted in the investigation. Then government explained how officers discovered Animal the following day after the robbery and recovered evidence of the crime from inside the getaway vehicle, his backpack, and garage of the residence where Animal and co-defendant were located. Thereafter, Animal was sentenced on May the 25th of 2022. The sentencing hearing was even shorter than the plea hearing, lasting just 13 minutes. The district court adopted the pre-sentencing investigation report, which provides for the United States sentencing guidelines imprisonment range of 57 to 71 months for count 1 and a consecutive mandatory minimum imprisonment range of 84 months to life for count 2. That's a lot of time, man. But that is apparently the deal. So, of course, what you can be sentenced to ultimately is like up to 20 years, as the judge said earlier. But what you will be sentenced to is, at least in the first instance, determined by the guidelines. And they have nice charts for this that detail what different sentences you are expected to receive. And then the judge can depart from there. The guidelines are based on how bad have you been in the past and how bad is this offense? And both of those things have numbers associated with it. So you go through the offense and you say whether or not various things are true or not. The various things have points assigned to them. You add up the points. It gives you the point that you need. You look it up in the little chart, and that gives you the number. And apparently, in this case, 57 to 71 months for count one, and consecutive, which means then on top of that, how about 84 months to life? That's a lot of potential sentence, man. At the sentencing hearing, appellant's counsel, Animal, presented a number of animals in support of mitigation. Namely, Animal's counsel argued for a downward variance because of the fact that Animal was completely cooperative with law enforcement, completely admitted to what he did, and showed he was sincerely remorseful by writing an apology letter. Okay, I mean, it's not nothing. Animal's counsel further argued that Animal had a history of severe mental illness, namely schizotypal personality disorder, noting that Animal entered inpatient care starting when he was 16 years old. Animal's counsel highlighted that Animal was not taking his medication at the time of the robbery, and that Animal also had a significant history of heavy drug use, including methamphetamine and heroin, no, you don't say, exasperated by his father's death in 2020. Animal's counsel further noted that Animal had recently lost several family members and that he was a caregiver to his wife was fully disabled. Well, I mean, that's a lot of things going on in Animal's life, but I'm not sure that the armed robbery was the therapy that we would recommend. So it sounds like, he might need to do something to perhaps deal with these traumas in his life, which seem like they're significant. But armed robbery, not the preferred method. Maybe he could lift weights or take up a hobby or something. Maybe less with the armed robbery, though. But okay. Therefore, Animal's counsel saw a downward variance of 96 to 120 months of imprisonment. In further support of the variance, his lawyer argued the following: a below the guideline sentence can still be sufficiently punitive and deterrent. The longest previous sentence that he has served was 4 years. Even if you gave him twice that, or even a little bit more, you don't have to go as high as the guidelines ask for. Animal understands that as a lengthy sentence is warranted and necessary, but it doesn't have to be as lengthy as the guidelines call for. Okay. In opposition to the downward variance, the government noted that Animal did not play a lesser role in the offense. It was not his first felony, that he committed another assault soon afterwards, and there's a footnote. According to the pre-sentencing report on June the 13th, less than a month after the offense we're talking about, Animal punched a victim in the face several times and then pled guilty to simple assault in state court. He may have control issues. And there was nothing in Animal's record warranting a downward variance. The government therefore requested a within guideline sentence for count one, followed by a consecutive 84 months of imprisonment for count two. In his allocution, Animal offered the following on his own behalf: I want to apologize, Your Honor. I've made a big mistake. I'm tired. I'm tired of living like this, Your Honor, and I'm trying to see my son graduate. You know what I'm saying? My wife out there, see? I left her out there. I left my mama out there. She's sick. I don't know what I was thinking. I can't do this. I can't keep doing this. I'm giving my too much time away. I can do better than this. I know I can. Please, I'm sorry. Well, I'm sorry about a lot of things too, Animal. But yeah. With respect to the relevant law sentencing factors, the district court stated that it considered the imprisonment range prescribed by the guidelines, as well as other relevant factors set out forth in the advisory sentencing guidelines and those set forth out in various law. The court therefore sentenced Animal to 60 months of imprisonment for count one, which was on the lower end of the guideline range, and to the mandatory minimum of 84 months on count two, for a total of 144 months. So, I mean, it seems to me that Animal's getting a pretty decent deal out of this judge, to be quite honest, because the guidelines range was, what was it again? Let me go just back up here so I can find what it was. The guideline, wasn't it 55 months? Where is it? I'm having trouble finding it. I hate it when that happens, when I can't quite find something when I need it. That's annoying. The guideline range was 57 to 71 months. Okay, the guideline range was 57 to 71. An animal here, in fact, got 60. So he got 60. I mean, and the guidelines ranges are presumptively correct. And so he's on the low end of the guidelines range, 60 months plus 84. He gave him pretty close to the least that he could give him. And the Court of Appeals wants to give the lawyer give him a hard time for this. Also, incidentally, by the way, of course, the second judge, when he's doing the sentencing, could give him a different number. Because the issue here is the validity of the appeal waiver. So he may want, and it's before a different judge at that. So the different judge, when he's doing sentencing over again, he's going to redo sentencing over again from square one for sentencing. The guilty plea isn't the problem. The sentencing is the problem, apparently. So that judge is going to redo the sentencing completely. And then how that judge looks at it is up to that judge. So if that judge, minds his P's and Q's and does everything he says and says, you know what, I want to sentence you to a new exciting number. How about like 200 months or something? Animal has a real problem here. So I think Animal may be in the category of be careful for what you wish for, because Animal was already on the low end of the line. And was his appeal waiver knowing and intelligent and voluntary? Maybe not. But it feels like he's heading into a precipitous path. As his attorney, I think I would recommend against appealing. It is his right to appeal. But I think I'd recommend against appealing. I don't think it's going to get any better, Animal, and it's probably going to get worse. But Animal doesn't see it that way and apparently wants to appeal. Okay, I don't know, man. I'm not sure about that. So anyways, 57 to 81 was the possibility or the range proposed, and how about 60? Plus, how about the minimum of 84? All right, then as to the issue of the appeal rights, this is, I think, where things are boiling down. As to his appeal right, the district court stated, Kwame Smith, you can appeal your conviction if you believe your guilty plea is somehow unlawful or involuntary, or if there's some fundamental defect in the proceeding that was not waived by your guilty plea. You have the statutory right to appeal your sentence under certain circumstances, particularly if you think the sentence is contrary to law, which incidentally, it's not. It's not contrary to law. That's not the problem. However, a defendant may waive those rights as part of a plea agreement. If you've entered into such a plea agreement which waives some or all of your rights to appeal the sentence itself, such waivers are enforceable. But if you do not believe the waiver is enforceable, you can present your theory to the Court of Appeals. On appeal, he timely filed a brief pursuant to Anders, questioning the sufficiency of the district court's explanation for the sentence, but noting that the claim fell within the scope of the appeal waiver contained in the plea agreement. The government then moved to dismiss the appeal based on the appeal waiver. This guy is going to wind up on the wrong end of this thing. I can already see it coming. I can already see it coming. This guy is going to regret appealing. He's going to get his new judge. His new judge is going to do all the things that the new judge needs to do, and the new judge is going to sentence him to a new, exciting, and bigger number. And then he's going to complain to the Court of Appeals, and the Court of Appeals isn't going to care. So when this guy gets sentenced for 200 months, just remember, you asked for it. This is appealing this was a bad idea. Appealing this was a bad idea. Okay, but we're going to do it anyway. We review the validity of the appeal waiver de novo by considering whether waiver was knowing and voluntary based on totality of circumstances. Nevertheless, where defendant fails to move in district court to withdraw his or her guilty plea, but seeks to withdraw the plea on appeal and challenge of a forfeited Rule 11 error, we've reviewed for plain error. We review all sentences, whether inside, just outside, or significantly outside the range, under a deferential abusive standard. Good luck. In reviewing whether a sentence is reasonable, we ensure the district court committed no significant procedural error, such as by failing to calculate or improperly calculating the guideline range, treating the guidelines as mandatory, failing to consider the relevant factors, selecting a sentence based on clearly erroneous facts, or failing to adequately explain. So did the district judge fail to do some of those things? Maybe. Maybe the district judge did skip a step or two, but yeah, I don't know about that one. The appropriate standard of review. Could he claim ineffective counsel if this appeal goes backwards? Hypothetically, yes, but that depends on what his lawyer told him. It is his right to appeal. If it is his right to file the appeal. And so if I said, this is a really bad idea, you really shouldn't do this, and he's like, I'm going to do it, I'd be like, okay, I gave you my best advice. You know that this could turn out badly for you, right? Sure, okay, I gave you my best advice. So hypothetically, yes. Practically, probably not so much. The appropriate standard of review. Appellant and the government rely on different strands of our precedent, disagreeing about the appropriate standard for determining whether to enforce an appeal waiver. Applicant argues de novo. In support, applicant points to United States versus Butcher, where we stated we review the validity of an appellate waiver de novo to determine whether the waiver is enforceable. A valid appeal waiver is one entered into by defendant knowingly and intelligently, a determination that we make concerning the totality of the circumstances. In contrast, the government contends that plain error review applies to unpreserved Rule 11 violations. Fair. In line with the precedent that appellant identifies, we review de novo the validity of appeal waivers and decline to enforce invalid appeal waivers, where the appellant contests the validity of the appeal waiver as opposed to the validity of the appeal agreement. So we're going to go with de novo. Okay. In line of precedent on which the government focuses, we review the validity of a plea agreement. I mean, to be fair, the standard of review is a big deal, right? De novo is the best possible position to be in if you want your appeal to succeed, because then the appeal court can just decide for themselves. If it's not de novo review, if it's something else, then the appeal court is much more constrained. And so it's much harder to win your appeal. So de novo is definitely what you want if you want this appeal to succeed. So congratulations on that. It's de novo, so you're in the best possible position to win your appeal. Doesn't mean you will win. It just means that they're not constrained by the court below. Okay, great. In line of precedent on which the government focuses, we review the validity of a plea agreement under plain error standard review, where the appellant contests the validity of his entire plea agreement by challenging the conviction and seeks to withdraw the guilty plea. All right, fine. So what are you appealing? Are you appealing just the appeal waiver, or are you appealing the entire thing? And that drives it. Fine. So if you're trying to appeal the entire appeal waiver, then we're going to have a different standard, or apologize. If you're trying to appeal the entire plea, it's a different standard. If you're just trying to appeal the appeal waiver, that's a different standard. Fine. All right, great. We seek no disharmony between these two lines of cases. You can separate it. Where an appellant does not seek to withdraw his underlying plea, but instead challenges the appeal waiver as unknowing and involuntary, we review the appeal waiver. De novo. Fine. So the plea remains in place. The plea agreement remains in place. His guilty pleas remain. And now we're just concerned with literally the appeal waiver. That's all we're concerned about. Okay. On the other hand, where applicant seeks to withdraw his guilty plea based on a forfeited Rule 11 errors because he would not have entered the plea agreement but for the error, then plain error. Fine. The First Circuit has adopted a similar approach of reviewing the validity of appeal waivers de novo and declined to enforce unknowing and involuntary appeal waivers. Waivers, if appropriately drafted, assert to the defendant and explain defendant, should be honored. But the baseline for any waiver of rights is the defendant enters into it knowing and voluntary. I'm not disagreeing that that's true. I still think this is a dumb appeal. It's like, you're right, but it's still dumb. It's not going to get any better, man. The First Circuit summarized how appeal waiver enforces in United States versus Villados versus Rosera. Appeal waivers are binding so long as the written plea agreement signed by defendant contains a clear statement elucidating the waiver and delineating its scope. The district court ensures defendant freely and intelligently agreed to waive the right to appeal the forthcoming sentence by inquiring specifically at the change of plea hearing into any waiver of rights, and the denial of the right to appeal will not work as a miscarriage of justice. Thank you, Dean Dennis Phillips, for becoming an uncivilian. It is appreciated. In doing so, the First Circuit distinguished the Supreme Court's opinion in United States versus Dominique Benitez. The Supreme Court's requirement that a defendant must show a reasonable probability that but for the error he would not have entered the plea was articulated in the context of a defendant who seeks to reverse his conviction after a guilty plea. If imported into the realm of appellate waiver enforcement, this plain error standard would be significantly more demanding than the knowing and voluntary standard set forth in a different case. Okay, fine. I'm still on board with this. This is fine. So the standard basically amounts to knowing, intelligent, and voluntary. That you're doing it knowingly, intelligently, and voluntary. You understand and you're agreeing to it. It's like, okay, I understand that. And maybe that wasn't true in this case. Still a dumb idea. Cody Sams, isn't this kind of appellate just reserved for situations like the judge not completely honoring agreement and giving a higher sentencing? Well, unless you're in a particular set of circumstances, most of the time judges are not bound by the agreement in terms of the agreed sentence. There are a few exceptions. There's like one exception in federal law, but it is a specific kind of plea. But and it can be true in state law. But for the vast majority, the agreement for the potential sentence is an agreement just between the parties as to what they believe. And judges typically honor that, but they're not required to in the first instance, except in some limited situations. So as a judge, the standard thing would be like, okay, you agreed to the plea, sentencing is up to me, I can sentence you up to the limit, you agreed to less than the limit, how about the limit? Right? I can do that as a judge. And then you can't complain about it. You can complain for different reasons. You can complain that my sentence was grossly disproportionate, but then it's an abuse of discretion standard, right? So it's like you can't complain that I didn't honor the agreement. I was never bound by the agreement as the judge. Your argument has to be that my sentence was either illegal, I sentenced you to more than you're legally allowed, I sentenced you to 20 years when the max was 10, so you can appeal that, or then that's just legally wrong. Or you can say it's an abuse of discretion. Like technically yes, but practically no. But most of the time, judges are not bound by the agreement. So that's part of the deal. There are a few exceptions though. So you're not completely wrong for thinking so, but that is an unusual situation. But thank you for the question. Critically here, an applicant does not seek to rescind his plea agreement or challenge his conviction based on the asserted Rule 11, nor does he assert that Rule 11 error affected his decision to enter the plea. Rather, this argument centers around the fact that Rule 11 error resulted in unknowing involuntary appeal waiver. As a result, we distinguish. Fine. We therefore review de novo the waiver. Fine. I have no problem with that as a matter of law. All that makes sense to me? Great. We next review whether animals' appeal waiver was knowing and voluntary. When the government invokes an appeal waiver, we enforce it if it's valid and if the issue falls within the scope of the waiver. I mean, duh, right? So again, the waiver can be detailed. Sometimes you're not necessarily waiving everything. Sometimes you're only waiving some things. It depends on the nature of the agreement as to what you're waiving. Sometimes you can appeal your sentence. Sometimes you can even appeal the conviction on constitutional grounds. So it just depends on what the waiver is. So first of all, what is the scope of the waiver? It's a contract. It's a contract. So what's the scope of the contract? And like any contract, did you agree to it? So, I mean, it's just contract law principles. It's not that hard. A waiver is valid if the defendant knowingly and intelligently agreed to waive the right to appeal. Whether a defendant knowingly and intelligently agreed to waive his right to appeal must be evaluated by reference to totality of circumstances. And incidentally, treating it like a contract also makes you understand like why the judge is typically free to do what they want, because the contract is between the parties. The judge is not a party. He's not a party to the contract. Like, it's like, oh, we agree. How about 60 months? I'm like, that's super interesting and all, but I'm not a party to this contract. How sad for you. Yeah. Sufficiency of the colloquy. Rule 11 of the Federal Rules of Criminal Procedure outlines the requirement for the district plea colloquy, our little conversation we have to have, designated to ensure the defendant understands the law of his crime in relation to the facts of his case as well as the rights of a criminal defendant. In line with the dictates of Rule 11, our case law makes clear the district court must ensure defendant understands the nature of the charges to which the plea is offered, any mandatory minimum penalty, the maximum possible penalty, and the various rights they relinquish. Yeah, you have to understand what you're pleading guilty to. What is the offense? What minimums, if any, what maximums are possible, and what rights are you giving up? I mean, fair enough. The instant case turns on the relevant rule. The relevant rule requires the district court to address the defendant personally in open court and inform the defendant of and determine the defendant understands the terms of any plea agreement provision waiving the right to appeal or collaterally attack the sentence. Animal argues the district court failed to review the terms of the appeal waiver with him, failed to confirm that he understood the appeal waiver, and incorrectly stated the terms of the appeal waiver by informing applicant he waived his right to appeal his conviction, as opposed to waiving his right to appeal his conviction and sentence. I guess. Okay. Animal contends these failures renders his acceptance of the terms and the plea agreement appeal waiver unknowing and involuntary. The government responds that the appeal waiver should be enforced based on the district court's substantial compliance. The government insists the waiver was knowing and voluntary because the court questioned applicant, Animal, during the plea hearing regarding his waiver. An important fact in evaluating whether the appeal waiver is knowing and voluntary is whether the district court sufficiently explained the waiver to the defendant during the plea colloquy. But the district court's failure to strictly abide by Rule 11 will not render the waiver unenforceable. A waiver is generally valid if the district court questions a defendant regarding the waiver of his rights during the colloquy, and the record indicates defendant understood the waiver. So, you have to kind of do all the things, but you don't necessarily have to do all the things in a particular way. So just the fact that you didn't necessarily follow like the exact thing is not enough. You kind of have to do it, but not necessarily the way the rule dictates. So if it's there in substance, it's enough, even if you didn't necessarily do the steps as outlined. Doing the steps would just be the easiest way to solve this problem. Incidentally, just follow the steps, but you don't necessarily have to if it's there in substance. All right, fine. It's clear from the record the district court failed to properly advise and question Animal as required by the rule. The court did not explain what the appeal waiver meant or explain that exceptions existed to the waiver of the rights. That is, ineffective assistance of counsel, which is always a valid ground of appeal. A valid ground doesn't mean you'll win. Really hard to win, but it's valid. Prosecutorial misconduct, sentences in excess of the guideline range, or constitutional error. Worse still, the court misstated the terms of the appeal waiver by informing Animal he only waived his right to appeal his conviction as opposed to his conviction and sentence. Okay, I mean, I understand this. I get it. I'm not sure I 100% agree with the Court of Appeals here, to be honest. I think they're being perhaps a bit anal on this. I'm not sure why. But, okay, be that as it may, the judge didn't mind his P's and Q's. All right. Because the court only informed Animal that he waived his right to appeal his conviction, the court mischaracterized the terms of the waiver. Furthermore, although the severely truncated plea hearing that occurred here is insufficient to comply with the rule, the case reflects a much more serious error than failure to strictly abide. Okay, well, maybe there's something more that would turn it for me. In this case, the entirety of the district court's discussion of the appeal waiver was, you're entering into a plea agreement in which you waive your right to appeal and waive your right to contest the conviction and any post-conviction proceeding. I've read and summarized the plea agreement. Is that what you've read to? They responded, yes, sir. The court did not ask whether they reviewed the plea agreement with counsel. Yeah, this is a bigger problem, right? This is a bigger issue. Nor did the court ask any questions designed to elicit a response indicating they understood the appeal waiver. Instead, the court simply asked if it was what you agreed to. Consequently, the court failed to determine or ensure they understood the meaning. Yeah, that was probably the biggest fail, right? The court not asking them whether they had read the plea agreement with counsel, right? Because the written agreement probably spells everything out as you would expect, right? So the written agreement, but the judge has to confirm it. That's the whole point. So if the judge had simply asked, have you read this agreement in full? Have you read it with your attorney? Have you had an opportunity with your attorney to ask him any questions? Have all your questions been answered? Do you understand the written agreement as you've read and agreed to? If the judge had asked those questions, it would probably be sufficient. But the judge didn't ask those questions. And also, the judge didn't necessarily have to ask those questions because the judge could have just simply gone through it himself and confirmed it, right? He could have done it that way. It's like, okay, do you understand this thing? Do you understand, just gone through it himself. But he didn't do any of those things. He didn't do anything. And so all he did is basically summarize the agreement, and he summarized it very badly. And so we don't have confirmation from the defendant himself in open court, which we're required to have. We're required to have it. We do need him to orally say, you've been advised of this and everything. We do need to do it. And you didn't do it. You didn't do it in any way. And so that's the problem. Okay, that makes sense to me. Therefore, they did not sufficiently explain the waiver. I understand. This is still a really stupid appeal, and the defendant should not be doing this. The totality of the circumstances includes consideration of animal's understanding of the appeal waiver. To determine whether the waiver is knowing and intelligent, we also examine the experience and conduct of the accused, as well as his educational background and familiar with the terms of the agreement. I mean, to be fair, although they are beating up on this district judge a little bit, to be fair, we do need to make sure that everyone's aware of the rules to protect all defendants. So this may in the end screw over this particular defendant, although strictly speaking, he screwed over himself. But we do need to do this because we need to make sure everyone's rights are preserved, including your right to be stupid. I mean, fair enough as far as it goes. Animal argues the totality of circumstances demonstrate his appeal waiver was not knowing and voluntary. In support of his position, Animal relies on his history of animal illness and minimal education. The government counters that Animal was aware of the appeal waiver and understood it, particularly considering he's familiar with the justice system. That argument isn't as persuasive as I think the government would like, because not all waivers are born equal, right? I mean, your familiarity with the system and your familiarity with waivers, but not all waivers are born equal. So just because I've seen 5 other waivers doesn't mean I necessarily have seen this waiver, because they can be fairly customized. They can be it depends what you kind of agree to. So yeah, I'm not really sure his familiarity with the system gets you where you want to be, but I appreciate the effort. The government contends that his background in mental illness and drug abuse did not prevent him from understanding the plea or its consequences. The government highlights that Animal had assistance of counsel, and both Animal and his attorney signed the plea agreement. Therefore, the government asserts nothing in the record reflects he didn't understand the significance of the waiver. But we need the oral confirmation, though. We need him in open court to be advised of his rights orally to make sure that he himself understands it. Orally. The judge is there to protect the defendant and protect his rights and make sure. So, yeah. Much of our precedent finding appeal waivers to be knowing and voluntary is distinguishable from the case at hand. In United States v. Soloff, we found the appeal waiver knowing and voluntary, where the magistrate judge confirmed the defendant's understanding of the appeal waiver provision and fully read the plea agreement appeal waiver provision into the record. See, that would do it, right? I mean, he just literally reads, the entire plea agreement or its waiver, and he reads into the record and be like, do you understand this? Yes, sir. Great. I've read it, and you've confirmed that you understand it. Outstanding. That worked fine. In Ice versus Blick, we determined that appeal waiver was knowing and voluntary, where defendant had a college education, and the district court specifically questioned defendant about whether he understood the appeal waiver. Again, depending on the questions, sure. In United States versus McGrath, we likewise conclude the appeal waiver was knowing and voluntary after finding the defendant understood the meaning and consequences of the waiver. This was true particularly because the defendant acknowledged he reviewed the plea agreement with counsel. See, again, if you had just done this, this would have been fine, right? This was true because defendant acknowledged he had reviewed the plea agreement with counsel, understood its terms, and sufficient time to consult with counsel before signing it. The court drew defendant's attention to the plea agreement waiver provision, and the court explained the waiver's terms, including the stipulated combined offense level of 43, and the guideline recommended sentence of life imprisonment before making a specific finding. The defendant understood that if the court sentences him at or below the level of 43, he has no level of right of appeal. Yeah, so like you actually just kind of went through it orally. It's like not necessarily hard, just takes a couple of extra steps. You know, and there's multiple ways to go about this, right? You could just literally read it into the record. You could ask the questions. There's a lot of potential ways to do this, but this district court didn't do any of those things, and so we don't have oral confirmation that he understood. So I mean, totally fair, totally fair. Applicant Animal acknowledged the plea hearing that he met with counsel prior to the hearing, but court did not ask Animal whether he had opportunity to discuss the plea agreement with counsel. Even if Animal had reviewed the plea agreement with counsel during the meeting, that would not be enough to cure the possible confusion caused by the district court here. We cannot say that Animal's history of severe mental illness and his minimal education alone would be a sufficient basis to conclude that the waiver was unknowing and voluntary. Of course not, right? Just because you have mental history problems or educational problems is not sufficient, right? That's not the standard. True. Nevertheless, this history, coupled with the failure to inform him of the terms of the appeal waiver, mischaracterization of the material terms, and failure to ensure that they understood the meaning of the waiver is sufficient for us to hold it's not knowing and voluntary. Fine. I have no problem with this. It's like under this combination of facts, it was not knowing and sufficient. You know, okay. I mean, fine. Especially if we're doing this de novo. Okay, sure. That I don't disagree with the conclusion. All right. As to severance, this is not the first time we've invalidated an appeal waiver on the basis it was not knowing and voluntary. In United States versus Wessel, we proceed to the merits of an appeal. Despite the appeal waiver, based on our finding, applicant did not knowingly agree to the absolute waiver of all appeal rights. In Wessel's, we established the remedy for unknowing and involuntary appeal waiver is to sever the waiver from the plea. Fine. That's perfectly fine. Great. The plea waiver or the waiver of the appeal rights can be severed, so you can appeal. Good luck. Subsequently, the 11th Circuit, interpreting Wessel, distinguished the concerns posed by involuntary and unknowing guilty plea from those raised from the unknowing and sans appeal waiver. I mean, they are distinct things. You can plead guilty without an appeal waiver. You know, you could plead guilty without an appeal waiver at all. There is no appeal waiver. I mean, that would be a little weird in many situations, but hypothetically, you know, I mean, you could just enter a straight plea of guilty right? I mean, you could just say, I plead guilty, and then you want to appeal. On what basis? I don't know, but maybe, right? Because you might be able to appeal the sentence, right? It's like, I plead guilty, and the judge says, how about 40 years? And I'm like, but it's a 5-year max, right? So I'm going to appeal. No, right? So yeah, you might be able to appeal, and you might have grounds to appeal. Yeah, so they're completely separate concepts. Guilty plea is separate from the appeal waiver. No, I understand this. The 11th Circuit ultimately held that for the appeal waiver, as opposed to attempt to invalidate the entire plea, severance is both practical and adequate. Yeah, that makes sense. Likewise, the First Circuit relied on United States versus Burchart to establish severance as a proper remedy, where a district court fails during Rule 11 colloquy to sufficiently inform the defendant of an appeal waiver and to assure defendant understands it. Moreover, in United States versus Mencken, we declined to enforce an appeal waiver after finding it unknowing and involuntary because the district court did not mention the waiver provision and, contrary to plea agreement, advised him that he would be able to appeal his sentence. Yeah, so again, the district judge told him the wrong thing. Whoops. And notably, 2 of our recent, albeit unpublished opinions further support severing the appeal waiver from the plea and decline to enforce the appeal waiver. Fine. Today, we make clear the proper remedy for the invalid appeal waiver is to sever the appeal waiver from the remainder of the plea and to relieve the defendant of the waiver. Perfectly fine. Yeah, perfectly fine. The waiver is not sufficient, so it's invalidated, but we're going to sever it from the rest of the deal. No problem. You can do that. Okay, I understand all those things. Fine. Let me have a drink of water. How y'all doing in chat? Tasty, tasty water. All right. The government asserts that if the appeal waiver is invalidated, it has not received the benefit of the plea bargain because it would not have agreed to other terms of the plea without its acceptance of the waiver. However, because we invalidate the waiver as not knowing and voluntary, we need not consider the prejudice. Yeah, I mean, that's unfortunate for you, the government. I mean, you screwed up. You know, that's sad for you and all. You wouldn't have agreed to it without the waiver. Well, that's unfortunate, but it's gone now, so sucks to be you. Oh, well. Therefore, we sever the appeal waiver from the remainder of the plea and we deny the motion to dismiss the appeal. All right. Miscarriage of justice. Even if the appeal waiver were valid, however, we'd still refuse to enforce it. Namely, because this district court's practice of omitting necessary information in both plea and sentencing hearings, disregarding proper procedure, and relying on appeal waivers to shield procedurally unreasonable sentences from view constitutes a miscarriage of justice, warranting our consideration of the merits appeal regardless of the validity of the appeal. So one of the reasons they're doing this is because they're really mad at this judge. We think that this judge in particular has been being very sloppy and hiding behind waivers to be sloppy, and we want more. So we're going to now take an opportunity to beat up on the judge. Not necessarily because of what they did in this case as such, but this is just a convenient excuse for us to beat up on you a little, and we're going to do that now. All right, so let's beat up on the judge for a while. We've refused to enforce valid appeal waivers for a narrow class of claims. Relevant here, we'll refuse to enforce an otherwise valid waiver if doing so would result in a miscarriage of justice. This narrow class of claims includes sentences imposed in excess of the maximum penalty provided by statute or based on constitutionally impermissible factor, such as race. Well, that would do it, right? That would do it. Sentence imposed while a defendant was deprived of counsel during sentencing proceedings, sentences imposed beyond the authority of the district court, and cases in which the applicant makes a proper showing of actual innocence, which is really fucking hard. In Taylor-Sanders, we've stated that while a district court's failure to consider a non-frivolous argument at sentencing might mean the sentence is imposed in violation of law, that is legal error, the appeal of which can be barred by an appeal waiver. Therefore, we decline to establish that cases merely touched by legal error are sufficient to warrant our application of miscarriage of justice, and correctly so. Were we to hold otherwise, it's difficult to conceive of a limiting principle that would prevent the exception from swallowing the rule that appellate waivers are normally given effect since nearly every appeal of a sentence involves a claim of legal error. So again, where does it stop is a question the courts ask a lot. So a mere legal error is not sufficient to say it's a miscarriage of justice. It might be something else, but this is an escape valve for something a little bit more than that. Although we're conscious of the need to maintain the narrowness of the miscarriage of justice exception, this appeal from this particular district court presents a far more egregious conduct than case merely touched by legal error. We stress that the exception would not apply in any less egregious a situation. And then they're going to tell you why this case is exceptional. They're going to tell you why this case is different from all the other cases. Why is this case so exceptional, Your Honor? Let me tell you why. The regular practice of the district court below to omit necessary information and disregard required procedure in both plea and sentencing hearings, knowing it's generally shielded by appeal waiver, cannot stand. They're really, really pissed at the judge. That's why it's different. We're really pissed at you. The district court, at best, minimally complies with Rule 11 while failing to accomplish the goals of Rule 11, but more often entirely fails to comply, as we've noted in the past. This is not our first time with this judge, and we are going to beat them until morale improves. And then they note a whole bunch of cases. I'm going to read the footnotes. Normally, I'd skip the footnotes, but we're going to read the footnote. We're going to read the parentheticals. Normally, I'd skip the parentheticals, but the parentheticals are important here because we're going to talk about how we've beaten up the judge before. So let's talk about some of the parentheticals. All right, see, for example, Kemp, in which we chastised the court for its less than perfectly clear discussion of an appeal waiver and noting that the court first suggested the defendant had not waived any appellate rights and then informed the defendant that it reserved the right to appeal from the sentencing excessive guideline. See also United States versus Lyons, noting a Rule 11 mission. See also United States versus Page, noting several omissions from the district court's plea colloquy. See also United States versus Page, noting Rule 11 omissions. See also United States versus Devalia. We would be remiss not to note the lack of compliance with Rule 11 and dozen errors or omissions at the Rule 11 hearing. See also Bailey. The district court's Rule 11 colloquy had several omissions. Rather than fully review the terms of the appellate waiver with the defendant, the district court informed the defendant that he was pleading guilty and as part of that process waived his right to appeal. This was the only mention of the appellate waiver during the plea hearing, and the court did not ask where a defendant understood the significance of the waiver. See also Abney. Noting among other admissions, the court did not correctly state the details of the waiver. See also United States versus Mills, stating the district court did not fully comply with Rule 11. See also United States versus Mencall-Ruse, noting the court's Rule 11 errors. The district court has also repeatedly, and with increasing frequency, disregarded our precedent regarding procedurally reasonable sentencing. See also United States versus Webb, noting the court failed to entirely address several non-frivolous arguments for lower sentences. See also United States versus Providence. We cannot find any rational explanation for this sentence. The district court failed to explain how the Senate factors support the sentence. It failed to explain why it rejected the government's non-frivolous argument in favor of the guideline sentence, and in fact failed to provide any sentencing rationale at all. See also United States versus Lemus, concluding that the court failed to explain its reasoning of the guidelines and failed to sufficiently explain the sentences imposed, and noting the district court's wholesale rejection of guidelines and its cookie-cutter approach that's the antithesis of individual sentencing. See also United States versus Carter, concluding that the court's variety of statements respecting the below-guideline sentence was not sufficiently individualized rationale or explanation. See also United States versus Hutchinson. After hearing the parties' arguments, the district court, without explanation, imposed the sentence. See also United States versus Gatford. Our review of the sentencing transcript demonstrates the district court did not address applicant's argument and provide no explanation for the sentence. See also United States versus Grady, reasoning the district court did not acknowledge or address the arguments. See also United States versus Costin. The district court provides scant explanation for the sentence imposed. The district court statements throughout the hearing are otherwise devoid of any analysis of the factors or consideration of applicant's remaining mitigation. The district court failed to provide any meaningful indication of the sentencing factors it considered or weighted afforded those factors, and applicant's arguments render its explanation insufficient. See also United States versus Walker, knowing the court failed to provide respond to any of applicant's non-frivolous mitigation arguments and failed to provide any explanation whatsoever for its sentence. See also United States versus McNeil. From this record, we cannot discern why the district court opted for the chosen sentence, nor we can find, based on the court's terse sentencing explanation, that the court conducted an individualized assessment or applied the factors specifically to him. See also United States versus Robinson. Holy shit. How long is this gonna go on, man? Stop. It's already dead. Holy shit. See also United States versus Robinson. Knowing that in the initial appeal, we remanded because the district court failed to provide an explanation for its chosen sentence, yet the district court again failed to provide explanation on a remand. See also United States versus Hernandez-Almeida, concluding the district court entirely failed to explain its reasoning and failed to consider applicant's argument in mitigation. See also United States versus Suge, concluding that noting that this is not the first time we've addressed the district court's truncated sentencing practices and urged the court to do more than the bare minimum. And finally, see also United States versus Miles, determining the district court's failure to state anything about its chosen sentence was clear and obvious error. Holy shit. Holy shit. Holy shit. Yeah, we tried telling you like 20 times. Holy shit, man. Unfortunately, we've reversed the court below with increasing frequency to no avail. Heretofore, the district court's omissions, failures, and disregard for our precedent have been effectively shielded from review by appellate waiver such as the one at hand. No more. Holy shit. A defendant who exercises a general waiver of the right of appeal does not subject himself to being sentenced entirely at the whim of the district court. Holy shit, dude. We hold that this particular district court's practice of frequently and repeated disregard for defendants' right to necessary information during plea colloquies and indifference to proper procedure during sentencing hearings, which stems from the court's knowledge its conduct would be effectively shielded by an appeal waiver, is a miscarriage of justice that remains unaddressed. Well, I think I might have to retract some of my snark for the appeal. Basically, I think every appellate lawyer who doesn't appeal this judge's decision is now possibly an idiot. Because the Court of Appeals just basically told you, we're done. We're done. We're done with this bullshit. And so basically, just appeal all the sentences, appeal them forever. Maybe you shouldn't be allowed to do sentencing anymore. You're a bad judge and you failed. Procedural error. Given that appeal waiver here is invalidated, both because it was not knowing and voluntary, and because enforcing it would be the result of miscarriage of justice, we turn to the merits of sentencing. Maybe you shouldn't be allowed to hear criminal cases anymore. How about that? Maybe no criminal cases for you. Maybe you can just stick to the civil side or something, and you can just hear civil cases. How about that? Oof. Appellant argues the district court procedurally erred because it failed to adequately explain a sentence or consider any of the potentially meritorious arguments for below the guideline sentence. A sentence is procedurally unreasonable if the district court commits such an error as failing to calculate or improperly calculating the guidelines range, treating the guidelines as mandatory, failing to consider the relevant factors, selecting a sentence based on clearly erroneous facts, or failing to adequately explain the chosen sentence, including an explanation for deviation from the guidelines. Our review of the district court's sentencing explanation is not limited to the court's statement at the moment it imposes sentence, but extends to the full context, including the give and take of a sentencing hearing. The requirement that a district court adequately explain the chosen sentence, including an explanation for any deviation from guidelines, is meant to allow for meaningful appellate review for sentencing determinations. The court's explanation must satisfy that it has considered the party's argument as a reasoned basis for exercising its own legal decision-making authority in light of the relevant law. Applicant argues the procedural reasonableness demands more of district courts than boilerplate recitations that could be cut and pasted into a sentencing transcript of any federal defendant in the country. Appellant also argues the court prioritized efficiency over proper procedure when it failed to provide an individualized response to appellant's argument in favor of mitigation. Therefore, appellant contends the court's complete failure to acknowledge the arguments was procedurally unreasonable. Again, you can just consider them like, it doesn't mean that they have to persuade you, but you have to acknowledge them, right? And be like, no, that doesn't really do it for me, you know? But you have to like acknowledge it and then say like, you know, basically no. Or, you know, that, yeah. Significantly, the government agrees. The government readily concedes that the sentence was procedurally unreasonable. Defendant challenges the procedural reasonableness of a sentence on the ground the district court failed to provide a sufficiently individualized explanation that responded to his non-frivolous arguments. The government agrees the sentence is marred by reversible error. Wow. You agree the sentence that occurred after this plea was procedurally unreasonable, correct? Correct. Nonetheless, the government opines that on remand, it should be given the opportunity to invalidate the entire agreement. Because we invalidate only the appeal waiver by severing it, we decline. So we're not going to give you your remedy. Sorry about that. I'm sorry about that, but you know we're mad, and no, sorry. So you're still stuck with the plea agreement. Sorry about that. Deal. Here, the sentencing discussion by the district court was scant. The court simply stated the court has considered the ranges, as well as other relevant factors set forth in the advisory guidelines and those set forth in the law. The court did not provide any individualized analysis because it did not apply the factor to the circumstances, entirely ignored applicants' arguments, and provided no explanation or basis whatsoever for the sentence. Therefore, the court's explanation was inadequate because it does not reflect that the court considered the party's argument and it had a reasoned basis for exercising its own legal decision-making authority in light of law. In this case, without explanation, the district judge decided 12 years of applicant's life in 113 minutes. The government rightfully acknowledges it was procedurally unreasonable because it was. Woof. Finally, in light of district court's disregard for procedure and our precedent, we conclude this case should be reassigned to a different judge on remand to preserve the appearance of integrity. This is really unusual, right? It is really unusual for the Court of Appeals to send it back to a different judge. They are really, really pissed. They are really pissed. After all, we must seek to avoid both actual bias and mere appearance. Thank you, DSN, for the 5 gift memberships. When we remand a case, we may reassign it to a different judge when the appearance of fairness and impartiality is best advanced. Explain that even absent a claim of bias, reassignment is appropriate in unusual circumstance, where both for the judge's sake and the appearance of justice an assignment to a different judge is salutary and in the public interest, especially as it minimizes even a suspicion of partiality. Even absent finding a presumptive bias, reassignment to a different judge on remand would preserve the appearance of integrity. For the foregoing reasons, we sever the appeal waiver from the plea and deny the motion, and we conclude the sentence is unreasonable, therefore we vacate and remand. The Court of Appeals is pissed. Court of Appeals is pissed. Now, I'm still not necessarily sure that this is a good idea for our friend Animal over here, because when you redo sentencing, you redo sentencing. So the plea is still in place. The guilty plea is to count 1 and count 2. And they didn't say that the guideline range was wrong. They didn't say the judge miscalculated it or that he was wrong about the minimum sentence. So it's 84 months minimum, 84 months to life on 1 count, and then plus a presumptive 57 to 81 on top of that. And so, but when you redo sentencing, you redo all of it. And so the judge, when they review this case, is going to redo sentencing, and their guideline range won't change because it looks like that was correct. And he'll arguments from the parties as to arguments in aggravation and mitigation. And as long as the judge follows his P's and Q's and follows the steps, then he can sentence him to anything, absent abuse of discretion. So he was already on the low end of the guidelines range, and the guidelines range are presumed to be valid. But if this judge sentences him to, even if he went to the max of the guidelines range, because the guidelines range max is 71. So 84 plus 71, 84 plus 71 would be the max guidelines range. 155, which is divided by 12, is 12.9 years on the max of the guidelines range. But if this judge sentences him to even more than that, based on factors, maybe. So I don't know that it's going to get better for Animal, and it could get worse. So I'm still not sure this is in Animal's interest, to be honest. But, we'll see how it turns out for Animal. It seemed like he was already getting a pretty decent deal out of this. So, I don't know that he's going to save himself any time. And it's possible he could wind up with more time. And then it's just an abuse of discretion analysis, and good luck with that. But seems questionable. So we'll see. Yeah. This isn't Animal's first rodeo. I'd keep the deal. I agree with you, Tony. I think that this is unwise. I think this is an unwise appeal. It is his right to appeal, but I think it's unwise because I don't think you're going to do much better. I don't think it's going to get any better. Maybe the attorney pressured him to appeal. Maybe. It's possible, I suppose. But I don't know about that. So we'll see. Very, very interesting case. Thank you for the 464 of you who spent some time with me on Easter Sunday discussing this case. Turned out to be interesting, more interesting than I initially expected. So we'll see what happens next for our good friend Animal. This was decided April 14th, so, there's going to be a new sentencing hearing, and we'll see how it turns out. If the attorney misrepresented risk reward, I don't know. I mean, I have no idea what conversations his attorney had with him, but it doesn't necessarily surprise me that he appealed despite the deal, because it seems to happen a lot. And Natalie, the lawyer chick, has talked about this, right? People make a plea deal. It's even a really good plea deal. People make a really good plea deal, and then they decide they want to appeal, even though it's really dumb. And most of the time, they're not allowed to appeal, but they really want to appeal. They find out that prison really isn't that much fun, and they'd like to appeal anyway. But it's fairly common, right? You go through all this stuff, you go through all the plea, you go through everything, and then the guy's like, "I'd like to appeal," even though most of the time they don't have a grounds of appeal, or it'd be dumb. So it would not surprise me in any way that Animal was told that this was a bad plan, and he decided to do it anyway, and he decided to YOLO this thing. So, yeah. It's common to appeal a deal you accepted. Yeah. To try, at least. Yes, it's common. Yeah, people do it all the time. They do it a lot, I should say. Yeah, people do it a lot. They make a plea. They make a plea deal. They do everything. They go through all the steps. The judge does everything. They do all the steps, and okay, and then the person appeals. Happens a lot, or they try to, at least. Happens a lot. I don't, what can you say? But it happens. It is what it is. It is dumb. It is dumb. It's particularly dumb in this case, because I don't really see it getting much better for Animal. On the risk reward calculation, on the risk reward of this, it's what are the odds of it turning out better for him versus what are the odds of it turning out worse? I feel like the odds of it turning out worse are better than the odds of it turning out better. This feels like a bad deal for Animal, but Animal's going to do what Animal's going to do. I mean, after all, he did commit the armed robbery with the violence. He's not exactly known for his good decision making. So what can you do? Yeah, people conflate an appeal with a request to reconsider. Fair. Well, he got his request to reconsider. He got it. Good luck to you, sir, is what I have to say about that. So we'll see. You have a hummingbird cake? I want hummingbird cake. All right. So I think that's going to conclude us for today. Probably not going to do any more streaming today. I'm going to do kickball probably in about 2 hours, and probably just going to take the rest of the day off. But tomorrow we'll do something. I'm not sure what. And then Tuesday we pick up with the Karen Reed trial. Exciting and fun. So stay tuned for that. And then, of course, we're going to have to do daily videos like we did before. So Tony is going to be busy making graphics like he did last time for the thumbnails. So you can look forward to that, Tony, because last time we did some great thumbnails and we got really good videos out of them. So we will. Yeah, you can't wait for Free Karen Reed season 2. Yeah, season 2 could be lit. Season 2 could be a lot of fun. We'll see how it's going to turn out, man. All right, guys, I'm going to sign off for now. I love you guys. Thanks for joining me. I've been on Civil Law. Till later, my friends. I hope all's well. Cheers for now, my friends, and goodbye.